Welcome back to Hardball. David Boies and Ted Olson had the epic showdown during the fight over the 2000 presidential election and the Florida recount. Now they've teamed together on the same side to fight Proposition 8, the California ban on same-sex marriage. Ted Olson joins us from Washington, and David Boies is on the phone from New York. Ted, first, I'm impressed by you, sir. Again, I'm always impressed by you, but this time you surprised me. You're going to use the Liberty Clause of the 14th Amendment to stop states from outlawing same-sex marriage, right?
We're going to use the Equal Protection Clause of the 14th Amendment and the Due Process Clause of the 14th Amendment to argue that individuals are entitled to marry the person of their choice, and the Due Process Clause and the Equal Protection Clause precludes states from prohibiting same-sex individuals to have the same right to marry as other individuals. Oh,
David, let me try to get you to put that in English for the regular non-lawyer out. No, I mean this. I understand it, but I want it a little more human here. Are you saying that a person has a right to life, liberty, and property, and states can't deny it, and part of liberty is the right to pair off with whoever you want to pair off with, basically, to mate with for life? Is that what you're basically saying, liberty? Yeah.
Absolutely. 42 years ago, the Supreme Court decided that marriage was a fundamental right of liberty, that the ability, the right to choose the person that you want to marry and to be able to marry the person that you love was a fundamental human right that could not be abridged by the state in a discriminatory manner. And what the fundamental issue here in this case is it discriminatory to say that gays and lesbians, purely because of their sexual orientation, are unable to get married? We think it is. We think that is a central issue in the case, and we think it violates the federal Constitution for California to prohibit gays and lesbians from marriage.
Let me get back to Ted for the fight here to get 5 votes before arguments. If you argue this case before the Supreme Court, if you get cert, you've got a good shot, it seems to me, because of the Lawrence case, where you had 5 votes under the Liberty Clause and another one under Equal Protection, Senator O'Connor. But you've got that necessary minimum of 5 votes here if Sotomayor replaces Souter and thinks like him. What's your thinking on this in terms of the Liberty Clause?
Well, I think that the Supreme Court's decisions, the one that David mentioned about the fundamental right to marry, there's a case involving Colorado of a few years ago that said that the state could not discriminate against gays and lesbians with respect to access to the political process. That was a decision of the Supreme Court. And then the case you mentioned, Lawrence versus Texas, which was a 6-3 decision, as you mentioned.
Right.
We're talking about equality of individuals, and we're talking about denying them that right to marry, and there isn't a rational basis for California or any other state to take individuals and say they are unpopular, we don't like the things that they do in their relationships, and which the Supreme Court in that Texas case held to be constitutionally protected, but because we don't like those things, we're going to deny them the right to marriage. As David and I have been saying, this is not a liberal, conservative, Republican, Democrat issue. This is a matter of equality and treating people with dignity and allowing people that stable relationship that marriage produces.
Okay, let's talk about the word marriage, David Boies. The word marriage to a lot of people means man and woman. That means you get married, you have kids, the traditional way. How do you take that word marriage and apply it to same-sex relationships when it wasn't applied that way for most of human history in terms of the law? In terms of the law. I'm not talking people weren't gay or they didn't have relationships. I'm not getting into that because that's obviously not untrue. But in terms of law and recognition, we have it in the past in Western society, recognized in common law, the right to marry someone of the same sex. How can you find that right then, given there's no history of it?
Well, for example, I mean, historically, there has been all sorts of discrimination. Women couldn't hold property and couldn't vote. African Americans couldn't vote and couldn't own property and were slaves. It took until 1967 for the United States Supreme Court to rule that it was unconstitutional for states to prohibit blacks and whites from marrying each other. The fact that something has been done in the past doesn't make it right. And I think that one of the things that has happened in our society is that we've always believed in equal rights, but we've sometimes been blinded about who is really entitled to that kind of equality.
Right.
And I think we recognize today that everybody is entitled to that kind of equality.
Right.
And that when we look at somebody's sex, or we look at somebody's race, or we look at somebody's religion, or we look at somebody's sexual orientation, and we say they're a little less human than we are, they're really not entitled to equal rights, that's just wrong. And I think the Supreme Court made that clear in the context of marriage as well as other fundamental rights.
Let me go back to Ted. Could a state argue effectively that although the rights should be equal, the word marriage should apply only to male-female relationships because it means something under our language, that it has a particular linguistic meaning, marriage, and the states have a right to preserve that meaning, apart from rights? In other words, you could have same-sex marriage under a different name. It could be called same-sex marriage or same-sex something else. But can that word marriage be protected under the basis of the meaning of the word?
In fact, that's essentially what California does. They have something called domestic partnerships, which provides many of the same rights as marriage. What if we were to tell individuals after coming to this country and taking the test and becoming citizens, what if we told them, you're from Japan, you can vote, you can do all the other things that individuals can do who are citizens, but we are not going to allow you to use the word citizen because you came from another country, because you are Japanese or you are Mexican or something like that. That would be discrimination on an unacceptable basis, and that's what we have here. We're saying that we don't mind if you live together. We don't mind if you have the other relationships that exist in marriage. We just don't want you, because of your sexual orientation, to use that word marriage. We think that's unconstitutional. And I can't say it better than David did.
Okay. And remember, in California today, there are more than 18,000 gay and lesbian couples who are married and are using the term marriage.
Right.
And the California Supreme Court says that's fine. There are lots of states, increasing number of states, in which gays and lesbians can marry. So marriage is not just limited to people of different sexes.
Okay, let me go back to the politics. It's a little apart from your question, but it's really an issue that I've always thought about. We had the Supreme Court give positive review, constitutional review, and accepted the fact that we had the Civil Rights Act of 1964 that used the Interstate Commerce Clause on public accommodations. And we have no more prejudice in restaurants or presidents, certainly no public prejudice with regard or discrimination with regard to hotels, restaurants, public accommodations. It's been totally accepted. Whereas Roe v. Wade was a court decision, which basically came out of a court decision, not out of a law. Isn't it better to have same-sex marriage passed as law by states and then reviewed and supported by the courts, rather than have the courts take the initiative and then have this dispute go on and on and on like it has with Roe? Ted Olson.
Well, when that case that David mentioned, Loving versus Virginia, involving interracial marriage,
right,
at that point in time in 1967, it was accepted that states could prohibit interracial marriage. That didn't stop the Supreme Court from rendering the decision that said that that was unconstitutional. And people now think that that would be crazy to say that we couldn't allow people of different races to marry.
Right.
We would be saying, Chris, to someone who has a constitutional right to marry, wait a few years until 50 states approve that. Go stand in the back of the line and wait until the political process goes through its forms and people vote to give you your constitutional rights. You don't take your constitutional rights to the ballot box. They're protected by the Constitution. That is why we have a Constitution, and that's why we have courts.
Thank you very much.
Remember also that we wouldn't have had the Civil Rights Act without Brown against Board of Education. I mean, the Supreme Court had to step in and start that process. After that process was started, we had important legislative accomplishments. But the Supreme Court has been in the forefront of establishing fundamental rights for a long time.
Okay, thank you very much, David. And Ted, last night, on a personal note, my wife and I agreed once again how much we love Ted Olson. Thank you very much, sir, for once again impressing us in so many new ways.